Good morning. Good morning. Welcome here to the University of Miami. I'm Luis Onaten, and along with my partner in crime, there he is, Don Hayden. We are the co-chairs of this second annual LATAM Investor State Conference. It's really quite gratifying seeing that on a Sunday morning, seeing so many people here. It shows the interest in the area and how Miami has really grown to be able to host this type of program. Let's get some logistical things out of the way. Up here, and as well in your programs, there's an app. This app is particularly useful to go ahead and be able to vote on the different debates. So try to log in. You can also go ahead and ask questions, although we're also going to have microphones out so you can ask questions at the end of the debate as well. A word of caution. Each of the debaters has been assigned a role. Simply because they are arguing a particular position does not mean that that is their actual position. They've been assigned the role, and think of it that way. The Tilney Hall session at the conclusion, that's under Chatham House rule. Anything said there will remain here. So please keep that into account. Right now, let me call up Richard, the chair of MIAS, who's right here to say a couple of words.
Luis, thank you. Good morning. I had a 15-minute presentation that was going to walk through the history of MIAS, but because Luis started late, I'm going to skip that, and we're just going to get right into the activities. Before I turn it back over to Luis, I want to thank everybody for being here today early on a Sunday. I want to thank Luis, Don, who are the co-chairs of today's event, Sandra for everything that she's done, obviously, with respect to the University of Miami and co-hosting once again, and of course our executive director, I don't know if she's in the room, Ines, who's critical to making sure that everything that we are doing actually works out seamlessly. But on behalf of MIAS, thank you for joining us. We hope it's going to be an entertaining session today, and we really, really are proud that we were able to launch our inaugural Miami Arbitration Week. Thanks for allowing us to be part of that process, and enjoy the balance of the day. Thanks again. Luis?
Thanks, Richard. And now I'm going to ask that Diane Machen-Martinez, who's president of the Miami Law International Arbitration Society, to say a few words. Again, we're very grateful to the University of Miami for hosting this, and really the participation of the students is integral. So again, Diane.
Hello, good morning. Thank you so much for having us. As the president of the Miami Law International Arbitration Society student organization, it's a great honor for me to welcome you all. It's an honor for us to co-host such a remarkable event and bring together some of the brightest minds, STEM professionals, and have you all here. Thank you. The focus of our discussions today will revolve around Latin America. As we all know, this is such a complex area, but also it brings us so many amazing opportunities. And this is exactly what makes this event such a great place for us to be today. As we begin our discussions and debates, I would like to encourage all of you to actively participate, exchange ideas with all of us, and cultivate new collaborations that will enhance the field of investor state. I also want to express our sincere gratitude to Miami Law, the International Arbitration Institute, and the LLM program for their meaningful contributions and also for making this event a reality, and personally for us international arbitration students for providing us the tools to obtain a successful career in such a complex field. We are immensely grateful to all the speakers, panelists, and attendees who are willing to share their knowledge with us today. Once again, welcome, and we hope that this leaves us with leaves us all with valuable insights and connections to take forward. Thank you so much.
As you all know, this conference is structured around debates. It's not just talking heads spouting knowledge, but it's a debate. And so it's my pleasure to ask for the first debaters, panel debate to come up. Moderating this debate is an individual who really needs no introduction. Bernardo Cremades, who hails from Madrid, has his own firm there, and has been, well, Bernardo, I'm not going to say how long you've been in this field, but it's been long enough. But I ask that you and your debaters come up and start the first debate.
Good morning to everybody. First of all, thank you to the Miami University for inviting us to conduct this meeting in which we are going to debate. And we are going to debate something very timely. Yesterday, while I was on the flight, I read Global Arbitration Review. And in Global Arbitration Review yesterday, they were commenting that one of the agencies of the United Nations has released a report saying that states should withdraw from investment arbitration treaties. That's probably the end of the arbitration for investments. I think that's very timely, but anyhow, there are many people who don't believe that's going to happen. And that's the reason why I think this discussion today is going to be very interesting. I think the idea, the proposition is ISDS will no longer exist in 20 years. Probably we could rephrase saying, quo vadis investment arbitration in the future. And probably in order to introduce this discussion, I would like to make three questions. Where are we coming from? Where are we now in investment arbitration? And where are we going to? We are coming, you remember, from the diplomatic protection. The diplomatic protection had only an interest of the states, not in the individuals. And the individuals were protected because it was the interest of the states. And they conducted the whole thing, and they could renounce without taking into consideration what the individuals had to say. That was the protection of the interests of the states. Afterwards, we introduced the idea that through investment treaties, the states renounce to the sovereign immunity of jurisdiction. They submit themselves in a public offer to arbitration for the infringement of the treaty protection, and that was the beginning of the arbitration investments protection. You remember that the Washington Convention 65 was thinking in terms of protecting natural resources, oil, gas, minerals. Salini afterwards said that the investment protected could be the concessions. So we amplify the protection and the concept of investment. And then we had different, like Lucchetti against Peru, in which we introduced the good faith accepting from the state the jurisdiction. So we wanted to exclude corruption, fraud, and so on. And that was how arbitration progressed in our generation. We had the advantage of having seen how this modification of the international law has been done. The individuals, the companies were subject of international law, not only the states, but the personnel. And that's the way it's done during those decades. We admit that there was abuses of this arbitration, especially when we talk about concepts like legitimate expectations. I mean, it's really something we see in the jurisprudence, a real abuse about that. We see that fair and equitable treatment is so vague that some arbitrators went too far away about that, and there was a big criticism. The reaction against this criticism from the states is the negotiating treaties. The states have to negotiate treaties, and with the arbitrators, we are very happy to see that the treaties make it more concrete, those concepts. The states are the owners of the centers like the ICSID or the PCA, and they modify the statutes and the rules in that direction. The states were the owners of the big think tank of arbitration, which is UNCITRAL. And that's the reason why we come to this reaction against and in favor of arbitration in investment protection. We see that that's a big issue. Some institutions, like the European Commission, are in favor of creating permanent tribunals. We, the ones who are from the private sector, we believe that's increasing bureaucracy. I don't think investors will have confidence in bureaucrats sitting in Brussels or someplace just because they have big salaries, big pension rights, and just a bureaucratic attitude. As you see, there is a big criticism, both sides, and that's the reason why I understand today discussion is going to be very interesting. We have a wonderful panel with us. We have Diego Gosis, who is someone who is very experienced in arbitration, especially in investment arbitration. When I asked him to give a CV, he said and insisted, I am very proud to have been in arbitration against or in favor all those sitting in my panel. So that's very interesting. We have Margie-Lys, who is from Panama, and we know that he is university professor teaching international private law. She is sitting in the ICSID panel of arbitrators, and she is at the same time working, representing the state in those questions they have, especially with ICSID and PCA. On the other side, we have Deva Villanúa. We know her very well. She is really one of the leading arbitrators of the new generation. Vice President of the ICC Court of Arbitration, of course, member of the panel of arbitrators in the ICSID. So she is, even if she is very young, she is very experienced in arbitration, and we are very happy to have her to react to those very aggressive comments we are expecting from my right side of the table. And we have Renzo, who is King Spalding. I must tell that I am very fond of King Spalding. My son used to be in King Spalding, and I have the very best remembering about King Spalding. Renzo, you are really very welcome, because we know that nowadays King Spalding is one of the leading firms in investment arbitration. So that's the way. First, we are going to hear Diego. Please, Diego, start your intervention.
Thank you. Thank you very much. And of course, first of all, I want to thank for giving us parking to arrive and have this beautiful breakfast here on a very early Sunday morning, and to MIAS for the ability to meet with some very old friends and very good friends, and to see that all of you also woke up very early on a Sunday morning. So I had to give in a short couple of minutes a position on why we submit that investment arbitration should not exist within 20 years. I don't know that a lot more than what Bernardo has just said needs to be said, and we could just proceed to coffee break and let you ponder about the reasons that Bernardo already gave us, why it's prone to disappear within the next 20 years. But I think there's a couple of very important questions that remain open, or that have been answered contradictorily in the 1,000+ decisions that we've all managed to read in the different, let's say, outposts for investment law that we try to have breakfast over every morning. We get all the news in GAR, we get all the news from the different publications that tell us how many new contradictions have come to light. The ICSID Convention was entered into in March 1965. It's almost 60 years now. There are about roughly 5,000 international economic law treaties that have given rise to these over 1,500 cases out there, 1,000 of which we possibly have read or we had access to the decisions of. And there's very critical questions which still remain out in the open, without which we really cannot, as claimants or respondents, usefully argue a case and have a sense of what results we're going to get. What is an investment? If you start the discussion going to the ICSID Convention, Article 25, it's going to say, jurisdiction of the center, competence of its tribunals is limited to disputes of a legal nature directly arising out of an investment. But what is an investment in that context? And Bernardo mentioned a few minutes ago the decision in Salini, of which he was an arbitrator, and that was decided, I think it was 2001, so 20 years ago. Still 20 years later, we do not know, we cannot keep a definite tally of which of the many variations of the theories leading to whether there is a test, a firm, strict test for there to exist, for some elements to exist as a precondition for investment to qualify for protection, or all bets are off, and if you bring a packet of candy from Spain, as probably Deva would carry on, anything of value that she had in, and she paid, and she expects to sell here and get something of value, she could possibly say, well, that is, in the relevant treaties, considered an investment that would qualify for protection under the investor-state dispute system. But the truth is, 20 years after the first decision that, in a way, provided some systematic thought on the issue of whether investment exists, we still don't know it. Now, so we don't know what can be claimed. Who can claim? Well, we also don't know what happens Can a national of a respondent state bring a claim in investment arbitration if that person also has the nationality of another state? That's also an open question, of which, and by open question, every open question I refer to here is going to be cases for which hundreds of millions of dollars were claimed and either accepted in one case or rejected in another case almost simultaneously. So we don't know what an investment is. We don't know whether double nationals can or cannot bring a claim. We don't know what they can make their claims about. What really is fair and equitable treatment? And if you read those treaties from the 1990s, under which most of the cases brought in the last 20 years have been brought, you will find sometimes in like Article 3 or 4 something saying that each of the contracting states shall provide fair and equitable treatment to the investors of the other contracting state. Of course, who would say anything different? Now, how do you go from that to making my letter to Santa come true, and to make any PDF I have on my computer become the basis of expectations that have a face value through DCF or otherwise in the hundreds of billions of dollars? And that's something that is not entirely decided as yet. Now, what are the circumstances under which a state is exempted from liability? Is there a treaty exemption? How do we read it? Is there a national customary law exemption, and how do we read it? This is another issue that 20 years after we really developed a thick caseload that will allow us to, in reasonable circumstances, read some statistically relevant answers to these questions. We still don't know. So what is the state of emergency? What is necessity? What is the non-precluded measures, and how do they apply in the context of investment law? Also, another question with an open mark. Why is a lawyer who usually sits for the other side in my cases now sitting as an arbitrator in my disputes? That's also an open question out there that has not been fully answered. And first and foremost, why does it take 7 to 10 years to actually get a decision on these matters? So these are, I think, the most potent threats that have led to a big question mark on why would anyone now decide to spend the $5 to $7 million per party that it costs to litigate an investment dispute for 7 to 10 years before we get to a result which we cannot really foresee now. A commentator on Argentine procedural law in the 1940s used to say that given the chance of arguing a case before the Supreme Court, he'd rather have a coin, because flipping that coin would give him 50% chances of success. There was no knowing what the chances were before the Supreme Court. And I think that stands for the status of investment law now. And originally, my English accent does not reveal it, but I'm from Argentina. I practiced law in Argentina for 15 years, including practicing investment law from Argentina. I was counsel to Argentina in that deluge of cases that started almost 20 years ago. And at first they said, well, Argentina doesn't like it because, of course, he's the respondent, and there's 50 cases against them. But then also other countries in South America didn't like it, but then also other countries in Europe didn't like it, but also then some countries in South Asia don't like it, and also some countries in North America don't like it. And as it currently stands, no one really likes it. And so it's not the flavor of the month. It's costly. It's unforeseeable. It leads to, I think, the parlance in Ancestral Working Group 3 was that there were unjustifiable inconsistencies, which is quite a euphemism for the dastardly situation in which this plethora of decisions that have contradictory results have led us. And so, as a result of that, I would submit it's very unlikely that in 20 years we will still be doing the same errors that we've been doing for the last 20. Thank you.
So we expect you to react to that. Who is going to talk?
I'm going to be addressing what Deva just said. I think it is important that we first...
Closer to the microphone.
Me closer to the microphone? Sure. Is that better? Good. So I think the most important thing is that we settle what we do understand under investment state dispute system, dispute settlement system. The way I understand it, in order to be able to decide whether I think or not that in 20 years it will still be ongoing, is that I think it should be a broad concept that encompasses any kind of disputes, whether they come between an investor and a state for breaches of international standards, and they may come from the law, they may come from a treaty, they may come from a contract, I don't know where they are. So if ISDS is taking this way as a broad concept, I do think it is my view that in 20 years it will still be around. Now, Diego thinks the opposite. He says this system is based on very vague concepts. What is an investment? Who can claim? Who is protected? What are we protecting the investor against? What is unfair and equitable treatment? And I do agree, Diego, that this is kind of a vague system. It is true. However, I think we can, as Bernardo said, can implement some measures to make it more concrete. We could have contracts, investment contracts, the way we used to have them before the blooming of the BITs. It is a contract between an investor and a state. That does away with all the discussion whether this is a protected investor. The inefficiencies regarding who an investor is and what a protected investment is, the inefficiencies regarding what is protected, so against what specific standards, yes, I am also uncertain what fair and equitable treatment is. Do we go beyond a minimum standard of treatment? Are the legitimate expectations part of it? Are they outside? We have new BITs which are trying to be more concrete about what we are really protecting. But sometimes I get the impression in investment arbitration that these cases are decided a bit like the principle of pornography. Like, I can't really give you a definition, but I know it when I see it. But jokes apart, I think the criticism is correctly made, but we are on the way of really finding a way to cure those defects and finding a new system of ISDS, which proves to be more efficient. Of course, these inefficiencies, they lead to longer proceedings with excessive arbitration costs, I must say, largely due to counsel, not so much arbitrators. If you look at the numbers, and they're public, you will see who really gets the chunk of the cake. But of course, if everything was more simple, it will be shorter and cheaper. You also mentioned, Diego, that states don't like investment arbitration. And yet here they are. Here they continue. Some have left for good, some left and came back, and a lot of them are still here. So why are they here? Is it for charity reasons? I don't think so. I think states are still in this system because they need foreign investment. And they're discriminating, openly discriminating investors, and treating them differently as their national investors. And the question is this discrimination legit? Does it serve a higher purpose? And I think that's what states really how they feel, because discrimination is treating the same people differently. There's no discrimination if you treat different people differently. So are national investors and international investors, foreign investors, different? I think they are. And you can look back at history, all the attempts at autarkic economies. You can ask my grandmother, who almost doesn't know her name, doesn't know what year she lives in, yet she will tell you how she starved at the beginning of Franco's time, during the dictatorship in Spain. You can look at China, the late 50s. You can see North Korea. all the attempts at an autarkic economy have failed. So economies do need foreign trade, they do need foreign investment to thrive. I also wonder if what the excessive costs that you mentioned, Diego, you said the states are really not willing to take up the excessive costs associated with investment arbitration. I think that is quite a simplistic view of the whole diagram, how investment arbitration works. Because when you get investment, of course, that has a cost. And this cost of the investment will somehow be translated and passed through in the price of the goods that are being produced or the services that are being rendered. So every risk assumed by an investor, and we have a specific price tag for that risk, and it's called the country risk premium, so it goes, that will be passed through in the price. So the more risks that an investor is actually assuming, the higher the price of the goods and the services. So at the end of the day, it is not really a question whether we can live with or without investment arbitration. The question is, how much is the state willing to pay for the price of those goods and those services? Because believe me, if the investor has the feeling that it may be expropriated without compensation, that it may be treated in an unfair and unequitable way, and that there's no recourse to what it believes to be a neutral forum, all those risks, they will probably be assumed. I mean, people take risks. The question is, how much will that cost the constituents who are paying at the end for the price of electricity, for the price of the toll in the highway, for the water supply? That is the question. So is it really that expensive? Well, of course, I mean, states, when they are ordered to pay an award, that is money they have to pay. But at the same time, they're saving a lot of money and having all those products and services a lot cheaper. And this is just an anecdote that I'm going to give you. You're probably aware that Brazil doesn't have any BITs. The first time that I saw an arbitration in Brazil, it was a foreign investment. It was a commercial arbitration, but it was a foreign investment in Brazil. And I looked at the WACC. Are you familiar with that concept? It's basically what you have to repay the people that put money into your company to finance it. So the banks and the shareholders. So if you looked at how much that investor had to pay back the people that put money into the company there in Brazil, was 22%. I had just come out of university. I had seen all the exams that I'd seen in university were dealing with a 7, 8, 9% WACC. When I saw 22, I thought it was a typo. I really thought so. And it was an electricity company. That meant that electricity in a village in Brazil was almost 3 times as expensive as electricity in Norway. And that has really stuck in my mind. And I'm not saying that the only reason is that there's no BITs. I'm not saying that. But I'm sure that that was one, perhaps a tiny, perhaps a big component that made up that 22%. And the fact that Ms. Mendoza is paying 3 times as much as Ms. Eriksson for the electricity.
Thank you, Deva. Margie, may I turn to you now?
Thank you, Mr. President, and thank you to MIAS and the University of Miami for the invitation. It's a pleasure to be here in Miami, in this wonderful city. So, the ISDS system is in crisis. Opposing counsel admitted that there were some defects in the system, and they believe those defects have a cure, can be cured, right? I will submit that actually the ISDS system It has more as a terminal disease, so it no longer exists in 20 years. And I can enumerate several reasons besides those already mentioned by my co-counsel. Some of them: inconsistency in arbitral decisions, lack of predictability and coherence of the system, lack of transparency, the length and cost of the proceedings. We have heard a lot about costs this morning. But coming from a Latin American country, a developing country, we know how these proceedings can cost. Lack of appropriate control of review, and I will talk a little bit more about that later. And with all respect, Mr. President, lack of sufficient warranty of the impartiality and independence of arbitrators. So the question is no longer whether the ISDS regime should be reformed, but rather how and to what extent the structure of the investment arbitration needs to be reformed. So I will submit that the ISDS system will change in a way that it will no longer exist in 20 years. So, and I would like to focus on two different approaches. The first one, from a bilateral and a regional perspective. So at a bilateral level, and it was mentioned already, there have been treaties that have been terminated. Ecuador, Venezuela, Bolivia, South Africa, and treaties, countries that have chosen not to include ISDS. It was just mentioned by Deva, Brazil, for example. Then we have countries that have chosen to include a standing body, a whole tribunal, such as CETA and the EU-Singapore Free Trade Agreement, for example. Others have chosen to limit ISDS, to include carve-outs in their treaties, exclude certain sectors. Moreover, at a regional level, we have the EU that terminate all the intra-EU treaties in 2020. In 2023, the African Union states adopted a protocol investment, also terminating with all BITs between the state parties. I would like now to turn to the second approach, which is the multilateral level. At the multilateral level, we have, on one side, we have the UNTAC initiative of reforming investment arbitration and to provide more regulatory space for states in line with sustainable development goals. On the other side, we have UNCITRAL. As we all know, UNCITRAL Working Group 3 have received a broad mandate in 2017 to reform ISDS. And this, in particular, all the process and procedural reforms. So the UNCITRAL work is focused on procedural reforms. And we already have seen some of the products. For example, we now have a code of conduct for arbitrators that prohibit multiple roles. We have also some rules regarding mediation as an alternative to arbitration. Then we have, and I was last month in Vienna, discussing procedural issues and cross-cutting issues, the right to regulate, counterclaims, third-party funding reforms. This is changing the system, but not only for improving it, it will change in a way that ISDS, as we know right now, will no longer exist in 20 years. And I would like to refer to two systematic reforms in that way: the appellate mechanism and the establishment of a multilateral investment court. So for those, and you mentioned, Mr. President, that don't believe in a multilateral investment court as such, I would tell you that at least having an appeal mechanism would benefit the system. And the reason is because the system was not created for treaty-based arbitration. When ICSID was created in 1965, it was mainly to protect investments and investors that had a contractual relationship with the host state. That is no longer the case. So I will submit that an appeal mechanism will help to the consistency, coherence, predictability, and correctness of arbitral decisions. This will provide advantages that the annulment proceeding cannot provide. States shouldn't be faced, and the parties, also investors, to cases like the CMS case, where the committee faced really a problem because, notwithstanding the errors and the lacunas in the award, the committee says that it cannot substitute its own view of the law and its own interpretation of the facts for those of the tribunal, and therefore there was not an excess of powers. So with an appeal mechanism, this type of errors, manifest errors in the interpretation and the application of the law, as well as manifest errors in the interpretation of the facts, can be solved. Besides, it could improve diversity and independence and impartiality of the deciders. And with this, I finish my initial remarks. Thank you, Mr. President.
Thank you, Margie. Renzo.
Okay, thank you very much, Bernardo, and thank you to MIAS and to the University of Miami. So, we have been discussing here several criticisms to the system, right? We have talked about, our co-debater said that it has a terminal disease, that there is lack of predictability, delay, costs, lack of appropriate control, and lack of independence. We can talk about them all day, all the week, in this event and in other events, but the point and the question that I want to make now is whether this type of criticism existed 20 years ago, right? And what is the result after the criticism? And here I want to make an exercise. When I started working in Spalding, I was tasked with reviewing the UK-Peru VAT, okay? And I think this kind of anecdote is important, especially because I know there are a lot of students. So I had to review the Peru-UK VAT, and it was a pretty straightforward treaty. I read it, and I saw it was like 7 or 8 pages, and it was very simple, right? So I said to my supervisor, let's go ahead and file. There was nothing complicated to do. 2 weeks later, I was tasked with the same task, but with a Peru-US trade promotion agreement and with a Canada-Peru FTA, right? So I opened the document and it had 17 pages or more, and not only one section, but several sections, right? And I said, wow, this is completely different to what it used to be, what is the Peru-UK VAT. And if you look closely, you will see that the Peru-UK VAT was signed in 1993, while the Canada-Peru FTA was signed in 2008, and the US-Peru TPA was signed in 2006. they had substantive differences, a lot of difference actually. They just made it a bit more complicated to access ISDS, but it didn't disappear. The reason of the changes between one and the other is because the UK Peru BIT and that type of all BITs face criticism, so as a result, they need to be changed. But they did not disappear. They are still there. For instance, they introduced some changes that probably we all know here, right? The fork in the road provision because of the fear of abuse of process and foreign shopping. And also because some investors were still bringing claims in domestic courts, and at the same time in ISDS, under other names, they introduced a waiver provision, right? But also they started to include a series of carve-outs or exclusions to the protections, because there were certain areas of the law that dealt with the inherent powers of the state, policy power. They decided to exclude protection for certain type of claims, like general public policy exceptions, security exceptions, tax carve-outs, denial of benefits, among others. But at the end of the day, even after that type of criticism, 20 years after that, ISDS is still here. Of course, different to what it used to be, but still here. Now, the question, of course, is whether now, 20 years later, the response of the system is going to be the same, right? If it's going to be, again, a reform, more reforms, or just the elimination of the system. And I don't think there is anything indicative of the disappearance of ISDS in 20 years. It is true, and we cannot deny that probably criticism is now stronger, right? You have, for example, Chief Justice John Roberts saying that investment tribunals may have the power to effectively annul the authoritative acts of his legislature, executive, and judiciary, and that arbitrators can meet literally anywhere in the world and sit in judgment on a nation's sovereign act, right? Definitely, criticism is now stronger. But the answer to that criticism is going to be the elimination? I don't think so. Our co-debaters discussed about the UNCITRAL working group, right? That is analyzing the different avenues to address this type of criticism. Elimination of the ISDS is just one avenue, one option of the several options that we have in the table. And the interesting thing here is that the avenues that they are proposing, some of them may face exactly the same type of criticism that the ISDS faces now. Okay? For example, and our co-debaters spoke about it, the state-to-state dispute settlement, right? Or the multilateral mechanism to settle disputes, like a permanent court. Right? But I guess that type of solutions would probably face the same criticism as ISDS. Like, they will still say, hey, what about our domestic courts? You have a permanent court, everything goes to the permanent court, and we forget about the domestic courts. It would also be a forum for the investors, right? Not for the states. It's, for example, unclear how non-disputing parties would participate in this type of permanent court. There would be the issue also of funding of the system. Who's going to pay for it? The states, or is going to be paid by the investors who are filing the cases? This is all to say that those proposals that entail the elimination of the ISDS will probably face the same criticism that ISDS faces now. A final point that I would like to make is that I guess a lot depends also on the picture of the day, right? For example, we see Honduras is hit with a large claim. And then there is a way of criticism to the system. You see legislators of the US pushing the elimination of the system. But at the same time, you see then a state-owned company from Colombia winning a massive arbitration, and everybody's happy with the system and with the arbitration, right? So it all depends at the end of how we see particular moments of time. And what I propose, and what we are proposing here, is to see the entire film. And to see the entire film means to go back 20, 30 years, see if the criticism existed, and see if the result of the criticism has been the elimination, which has not, or the reform. Thank you.
Thank you. I think after listening to everybody on the table, it's the moment to throw concrete questions, and we are delighted to receive questions from everybody in the room. My first question to the panel and to everybody is, do you think it's reasonable this recommendation we read yesterday in Global Arbitration Review from the United Nations, saying that states should withdraw from investment arbitrations treaties? Is that reasonable? Is that possible? We are going to. And I think, Renzo, you were right when you looked back some years ago, what happened, criticism, and what is the situation now. I remember many years ago when the Washington Convention 65 was negotiated, the father of the negotiation was Ronnie Broches. Ronnie Broches came to Madrid and asked me, that was many years ago, to introduce him to the Ministry of Foreign Affairs in Spain so that Spain could ratify the Washington Convention, because he thought that if someone does it first, like Spain, many other Latin American countries will do the same. I called the Ministry of Foreign Affairs in Spain, and they were delighted to receive the Vice President and Legal Counsel of the World Bank, because at that time Spain needed a lot of big financing from those institutions. We were received with a tapis rouge at the big palace of Santa Cruz, and after a couple of minutes of presentations, the ambassador, Aldasoro, at that time was the responsible person, well, what can I do for you? And then Ronnie Broches started talking about the Washington Convention. And after 10 minutes, the ambassador Aldasoro was furious. He raised up and said, what you are proposing me, it's a felony. Spain cannot renounce to the sovereign possibility, and you want to introduce through the back door private persons to decide questions of sovereignty. So please, the meeting is finished, and we had to go away from the palace at that time. 2 or 3 years later, Spain ratified the Washington Convention, and so did many people, many countries in Latin America. Why? Big privatizations needed big financing from everybody. IMF, World Bank said, if you don't create legal security through ratification of treaties, you will not get that finance. So everybody started ratifying, and that was the beginning of the big, big boom of arbitration everywhere in our countries. So my first question, do you think it's reasonable to put this question now, after so many years, after the practice, how it goes? Diego.
I'm delighted to get an out-of-agenda question in the schedule that we had in mind. I was under the impression we would have the chance to rebut what we heard from friends on the other side of the room, but I'll take Bernardo's question as the procedural instance to make a very short rebuttal on that. And what we last heard from Renzo was to answer this, we would need to look at the whole picture. It's a horror picture. Let's start with that. Is it reasonable to live now? I remember always, there's a phenomenal paper by Rusty Park. I said that on his way to university in Boston, he would walk by a shoe repair shop. I had a sign on the window. And it said, great service, low prices, fast turnover, choose 2 of the 3. In investment arbitration now, it's none of the 3. It's not cheap, it's not good, it's certainly not fast. And all that we hear in defense of the proposition that we will still be doing this in 20 years is that something will change, which I cannot really tell you how or what or why, but something will be much better in 20 years. I mean, every religious text I can think of starts with the same premise, but I think it's very costly a proposition, and Deva's point about the cost and who gets the better portion of that cost. This is not with how much the process costs, but what do we get in return? Because if this process, which costs millions of dollars to each of the parties, results in a completely unexpected result, which will be contradicted 7 months later by an almost identical case anyways, that is what I think should lead and does lead parties to think of different propositions. Is this system necessary to reduce costs so that a Brazilian homeowner can turn on the lights and pay 1/3 of what Norwegian parties do? Well, to my count, the country with the most VATs is Switzerland, but a hamburger costs $32. So I don't know if that's really the test, but that's what I had to respond to either opposing counsel or Bernardo's question.
Do you think it's reasonable, Renzo?
So, in order to answer to that question, I guess we need to also see what are the other options, right? We can, I keep insisting on this idea that we always focus on what could be better, right? If it's cheap, if it's expensive or cheap, if the system is not good. Diego just said that it's not good. I don't know what is the basis to say that the system is not good. Maybe it's not the best, but it certainly has good things. It's not fast, but I guess we need to see what the other options are, right? And when we see the other options, we probably have a horror movie as well, right? Like domestic courts, if I were an investor, I wouldn't like to go to litigate in a domestic court, at least not in a Peruvian court, okay? Probably in other countries in Latin America is the same, but I wouldn't like to go there. And probably I would not invest if I don't have any sort of protection, right? I would be dealing 10, 15 years litigating with people who are not necessarily sophisticated, save some exceptions, of course. So I wouldn't invest, right? And when you see stories of cases in Brazil or in Colombia, where you see how things are decided for large cases, large investments, you say no. I mean, maybe ISDS is not the best system, but it certainly works.
Thank you. The problem is that we come again and again to the very same situation. We have created a monster. Arbitration nowadays is not the artisanal arbitration used to be some years ago when I started my arbitration career. Now it's a big industry. Arbitration is very long, and being very long because we know that arbitration repeats in the proceedings many times the same thing. When you start filing arbitration, when you file the claim, the answer to the claim, reply, rebuttal, and when you start writing the memos for the experts and for the witness, then the oral hearing, you see a very nice QC reading again the documents you have as arbitrators already read, and then the conclusions. So we repeat post-hearing briefs 12, 13 times the very same thing. Arbitration, it's getting a very long proceeding, and it's very costly. I think it's a real scandal. When we see now that in some arbitrations, we see around the table of the arbitrators 100 lawyers. Only 2 or 3 speak at that session, but all of them, they charge probably $2,000 an hour. At the end, it's really scandal. And what do you think about this situation of modifying? Because we are all responsible. When you ask the parties, they say, oh, the arbitrators, they are very busy. They have to schedule arbitration proceedings in a very long way. And when you ask the arbitrators, they say the contrary. The responsible are the counsels. When we start discussing procedural arbitration number 1, we see that the claimant says, well, I need 9 months to present my claim. My God, why you need so time? You had all the time to think about the claim. You need now 9 months. Of course, the respondent will say, I need 9 months to respond. And then 4 months reply and rebuttal. So at the end, if we start now thinking in terms of arbitration proceedings, we have proceedings pending 4, 5 years. I mean, and we see the bill afterwards. When we see the cost, it's a real scandal. What do you think about the modifying this situation? Because really, one of the biggest criticisms is length and cost. Margie-Lys.
Thank you, Mr. President. You know, Renzo was right when he mentioned that treaties have improved over time. So I used to be a trade negotiator over 10 years ago, and of course they have improved substantially. But most of the arbitration proceedings are based on treaties that are from the 90s. Before 2010, if we can say, you know, the new generation of treaties is from 2010 and after, then most of the cases are based on those treaties. So what can we do with all those treaties that are out there? So we have, we mentioned some of the reactions of states. So, one option, of course, is terminate those treaties or replace it by new ones, but that takes time. And even if you terminate treaties, then you have 10 or 15 years of the sunset clause, so that treaty can also be applicable 10 years after you terminate with that. And then even if you have a new treaty, then arbitrators may interpret those treaties based on jurisprudence that is from other treaties that are old generation treaties. So something must be done. And I like that work, modifying, changing things. And in that, I think the work of UNCITRAL Working Group 3 is important because the idea is to create a multilateral instrument that could be applied for the old treaties. So in that, you can also improve, in only one instrument, you can improve all your old treaties. So, and that could be a big change. Thank you.
Deva.
I think things are changing. We see new faces. We see new faces as arbitrators. We see new faces as counsel. This is no longer, ISDS is no longer something that's only accessible to 10 big law firms. Like you see smaller law firms having the guts to actually say, no, I'm going to break this barrier and I'm going to be doing investment arbitration too, and they do it very well. So I think there was like a mental barrier that kept them outside, and you only had a small pool of arbitrators, a small pool of counsel, and everything is broadening now. So I think these new faces, they have less complicated diaries, and they also, as a selling point, they want to tell you, we're going to do this more efficiently. So I think this new generation of players will contribute to having hopefully a more efficient procedure. As to the procedure in itself, as always, having the parties being part of when you schedule the whole proceedings is of enormous importance. So we need to have the state there, we need to have the investor there to see exactly what counsel are agreeing on, what they are asking the procedure to be. And everybody knows that at least I have trying to implement as many tools as possible to keep the procedure as simple as possible. You are all suffering me because I like to constrain the document production as much as possible and trying from what I can do. The difficulty is, what can an arbitrator do? Can you go against the party's wishes? And I really try to ascertain in all the procedural meetings that I have that it is truly the party's wishes and not just counsel wishes. But if the parties want to have this big-sized arbitration, how much as an arbitrator can you do? How much as an institution can you do? Again, and this is not something that is specific to ISDS, so it's something that really, it's the same discussion we have in commercial arbitration too. What can we do to make it more efficient and at the same time not be threatened by any due process paranoia or any kind of other paranoias that really keep us awake at night?
Thank you. Margie, the big solution some people find now is to go to permanent courts of arbitration. They call court of arbitration or permanent tribunals. Do you think, as you are representing states, that states will have more confidence in those tribunals than is now? Do you think really that this big change, which is very doubtful, is going to be implemented? Because we talk a lot, UNCITRAL talks a lot, European Union talks a lot, but we don't see that people go to those tribunals for the time being. Do you think from the state's perspective, that's because at the end, arbitration is confidence? You go to arbitration or to a tribunal because you are confident you are going to solve your problems. Do you think the states are going to be more confident in those tribunals permanently?
Thank you, Mr. President. For many countries, yes, that is the solution. However, we need to accept that there will be some costs with that, and financing was mentioned. So that's why there's other options that have been, they're under discussions, and I mentioned the appellate mechanism, because with that, I mean, it have not been decided, but it could be an standing appellate mechanism, but also it could be a roster of the members, or potential members of the appellate body, and it could be administered by any institutions such as ICSID, the PCA, and other institutions that currently administrate ISDS cases. But the thing is that, and why many countries now think it will be a good solution, is because with the current system, at least for treaty-based arbitration, the current system could not solve problems such as the errors in the interpretation of the law and problems with manifest interpretation of the facts as well. So it is at least one way that these type of errors could be submitted and, well, I don't like the word fix it, but at least it could be addressed by an appellate mechanism.
Diego, do you think that these permanent tribunals will give more confidence to the states, or because is the reason to introduce that is because it's giving confidence? And second question, do you think that the appellate solution is going to be the right one? We have the experience of appellate solution in commercial arbitration, and my impression is a real disaster, in the sense that at the end you are just postponing, and in the commercial arbitration people want a solution, not a postponement like in the appellate going, because I mean lawyers, we never renounce to a recourse against something that is against our client. So at the end we are postponing. Diego, what is your impression?
I think those are very, very relevant and interesting questions. And I've been involved in different capacities. Actually, in the first session of Working Group 3 at Ancestral, I had the pleasure and the privilege of attending as an observator on behalf of MIAS. And so I have since changed hats. The double hatting in arbitration also works in this. And I then participated as a delegate for states in those discussions. And the biggest tension there, and I think that's going to be a big part of the discussion or of the acceptability test for permanent tribunal is a tension between the states that fare better in a multilateral discussion because they're so small that they have to band together in continental or other, I'd say, more communal trends to get traction in the community, and others, like very large states, that fare better in a one-to-one discussion. And so most of the positions you see opposing each other in the discussion of Working Group 3 is countries that prefer to have a one-to-one discussion. The US wants to talk to you, Bernardo. What's your power versus the US? Well, it's going to be small. But if you say, so Europe or Africa has this position, then, well, every small African nation, every small European nation has, I'd say, a multiplier of its voice. Who's going to lead the creation of that permanent body's composition? That's going to be, I think, the test for whether or not it's going to be preferable or not, as it's going to be more trustworthy or less trustworthy than the current situation. And I think that's a very big part of the current conundrum, I would say.
Renzo, from the investor point of view, do you think that's going to be more confidence instead of going to arbitration like it is, going to permanent tribunals?
If the permanent tribunals are probably designed the same way or in a similar way as ISDS is designed, probably investors might have the same type of confidence of going to permanent courts, right, or permanent tribunals. I think, and it happens often, right, when an investor, and it happens very often actually, when an investor engages in an arbitration and sees that it's taking time, that is costly, right, and at the end, the tribunal renders an award that goes against the investor, our clients tell us, wow, I mean, this system doesn't work. Of course, because they lost, right? But when they win, the system is perfect, even if it took time to issue the decision. And I wanted President to maybe, it looks to me like we're coming to an agreement here. We are co-debaters, right? Because they are proposing an appellate mechanism, but not the elimination of the system, right? Good or bad, but the system would exist, right? We can discuss if the appellate mechanism is efficient, if investors will like, if states will like or not, but at the end of the day, the system will remain in place, right? And that's what the proposition that we are here to defend.
It's hard for me to speak on behalf of the investors, but I think if we have a permanent court which is only composed of 15 different arbitrators and they have all been selected by states, I wonder whether investors will really feel that confident in having 3 out of those 15 designated by the states as the tribunal deciding on the case. Again, I cannot speak for them, but I think they'd rather prefer a system where it could be anybody of their choosing who will decide, at least be one of the members of the tribunal, and then have some saying on who's going to be chairing.
One of the big criticisms of the actual system is lack of inconsistency, in the sense that nowadays arbitrators feel to be prima donna, in the sense that you see that arbitrators try to create international law. Arbitrators feel that they are there to create law, in the sense that there is no possibility of case law binding the arbitrators, and that's creating the situation in which one tribunal might say the contrary, the other one has said. What's your position, Diego, on that?
I remember reading an award chaired by a very respected arbitrator whom I really like, personally and professionally. It's a case involving Peru, Sachapchun v. Peru. And it started a chapter saying the issue of MFN has been the coexis vexata in national law since the treaties between city-states in Central Europe in the 13th century. And I always asked myself, how is that relevant to the dispute? I mean, what does the history of the Hanseatic League have to do with what this Hong Kongese manufacturer of fish flour had to do with taxes in Peru? And how are these two strands of facts connected? I think to the extent decisions are public and publicized and read with keen interest by the entirety of the community, there will always be a situation that people want, you know, the better pros to be put out there for the public eye to see. And that's going to lend itself to a bit of a literary excess of sorts. And there is no theory of precedence in investment arbitration, but I've had annulment cases under ICSID convention where a decision came out in an unrelated case when the parties were already in Paris to appear before the committee 2 days later, and we received a note from the Secretariat saying the committee would invite the parties to start the hearing a day later, so in their opening remarks, they do reflect on the findings of this unrelated annulment committee that was issued just days ago. And so I think that it's somewhat inevitable that there will be, out of the need to develop a 300-page decision based on a 5-page treaty, you have to get that content somewhere. And so there's always going to be the watering grounds for that literature. Is going to be those prior decisions. There's going to be a contagion effect of what one tribunal says onto subsequent tribunals, unless things happen in camera and we keep decisions, isolated and secluded for 20 years after they're issued before they can actually be used for any legal research purposes.
Well, as a matter of fact, as an arbitrator, I must dare say that I am fed up about quoting the council cases which are not related to the one you are deciding. I think sometimes the council, the big mistake of the council is that they are speaking not to the tribunal to convince the tribunal, but to the transcript, or if the client is in the room, talking to the client who is going to pay his fees. And probably you see that the documents presented to the arbitrators repeat again and again and again the tribunal's decisions not related to that. And what is something surprising, they come to you, like me, for instance, telling me how I should interpret the Salini question, which I wrote it. So, and they make pages and pages to convince me how to make the interpretation of the Salini decision. So I think that's part of the abuses we have to see in the arbitration. So when people speak about consistency of arbitration, it's probably because they are forgetting the main goal of arbitration, which is to solve disputes, not to create jurisprudence. And that's the reason why probably we are discussing about that. But anyhow, Renzo, what do you think about that?
So the issue of consistency, I think, is a relative one, because if there is a consistent line of decision that is wrong, then it needs to be changed, right? An investor cannot expect consistency even if the case is different, right? I would like the tribunal, to recognize that maybe the consistent line of decisions in the past 20 years is wrong and needs to be modified for my specific case. But that's what I would expect, like as counsel for investors. I would expect the tribunal to read our facts, read the case law. Maybe there is case law that fits in our proposition, and ask the tribunal itself if that line of decisions should also be followed in our specific case. I wouldn't like a tribunal to follow a trend or follow a line just because it's a trend, just because there were 5 or 7 cases that decide an aspect on certain sense.
Deva, you are very well known about when you are drafting awards that you go into details and that you consider very much precedents. What is your opinion of what we are discussing now about consistency?
What I can tell you is that there's nothing more boring in this world than reading case law, investment arbitration. It's the worst that can happen to you. I think if there's such thing as hell, I think it's going to be reading investment arbitration awards one after the other. That's why I always tell, during the first procedural conference, I say, I hate reading case law. So please do select the one that you're going to be producing, because I will read it, and you better have me in a good mood reading it. Council hardly ever follow that advice, and they come up with, on every single point, like 30 awards in one direction, 30 in the other one. When you start reading them, as Bernardo said, it's very difficult that they really apply 100% to the case. There's always factual things that make them different. So I think the real problem here is the search tools. So council have these search tools where they just enter a word and that produces, 100 matches, and then they just produce every single case law when they really are not that relevant to the case. And that has led to more inconsistencies that they really should have been. That's the first thing. So if there's one point to take home, please do read the case law that you submit. It's a lot more efficient if you just submit 5 cases that are really really applicable to the case, and that you have seen and ascertained the relevance, because there's some arbitrators that will really be reading them. So the other thing, when you say that arbitrators are prima donnas, I'm not going to say I'm not one, and that they want to create law and leave a legacy and I don't know what. Probably you're right in that.
They're right.
It used to be.
They're right not to solve the dispute, but to be quoted in the future.
To be quoted in the future and whatever, and because, well, we heard Diego and he's correct. I mean, we'll go back to the BITs of the 90s, you've got 7 pages, and you need somehow to develop very vague concepts and turn them into a reality faced with the situation that has been put before you. But there's new faces in this world, new counsel, new arbitrators. I think this new generation is less tempted with creating a case law for the future and is more focused on really solving the dispute. And I can tell you that I have no interest in redefining pornography. So I'm not...
I'm surprised that today we have discussed many points, but there is one missing: third-party funding. Nowadays, I can tell you that most of the big arbitrations are dealing with third-party funding. Nobody goes as a private person or company to such a complicated arbitration proceedings without finding a funder. The funders are really on the backside of the arbitration scenario, conducting the whole business. I'm really used to say that the funders don't take decisions, that funders just fund and keep away. That's not true. We see that the funders really have, even last week, one funder say, I need a weekly meeting with all the people involved in this arbitration because I want to be informed every week how the proceedings are going at the end in order to make decisions. So how far we could say that arbitration is conducted on behind the screen through the funding of third-party funding? Diego.
I think the magnitude of the cases, the number of cases also has made it very difficult, I would say unfortunately, for parties to present their cases without the involvement of a funder. This inevitability, I think, creates a need for a lot of care that we do not consciously decide not to see conflicts that could be very problematic. But I don't see that there's any. I practiced investment arbitration, I'd say 97% of the time representing states and 3% of the time representing investors. And for full disclosure, I'm actually arguing a case representing an investor against Margie-Lys, and the chair of the tribunal is Deva. And so that has kind of keeping all of us on the clutch of the argument. But even having argued cases for states 97% of the times has not led me to think that there's a hidden cabal of funders and financiers in some back room, pulling the strings of disputes. It's for the parties to choose good counsel, and for counsel and those parties to choose very good arbitrators and to establish rules that protects the system. The system needs fuel, and that fuel's coming from the funders. There needs not be a lot of concern. Now, abuses have existed and will exist, and I think that it's a necessity of these side guys to find a way to regulate that while not preventing that from happening. Now, does that mean we cannot do investment arbitration the way we've been doing it for 20 years? So much has to change on this and so many other funds that I still stand behind the proposition that we will not be doing this the way we're doing this in 20 years, which was the original premise.
Thank you, Mr. President. So, well, inconsistency, of course, is a big issue, but third-party funding is a big issue as well. And states in particular are worried about the influence that third-party funding could have during the proceedings. So it's not only an issue of conflict of interest, because well, we have to recognize that not only ICSID, but also other institutions have included disclosure provisions for third-party funding, but it's not enough. So that work is now under discussion at UNCITRAL Working Group 3 to have full disclosure, not only of the existence of a third-party funder, but also of the agreement. And because there's many concerns regarding the influence of that a third-party funding could have during the proceeding, but also whether or not that agreement covers cost awards. It's really a problem when a state, and that had happened in the case of Panama, have won a cost award, and then there's no way that it could actually get that award because, well, there are no funds, right? So, and then also a problem of regulatory shield on the state. So because of all these concerns, there's a need for more disclosure, not only on the identity of the funder and or the beneficiaries of that funding. Thanks.
I think the issue of third-party funding is an interesting one because, first, it's a response to one of the critiques to the system, right? It's costly, so we have to find ways to find people who are willing to fund the cases, right? So it's an interesting response that the system itself has created to address that concern. And of course, I guess that the one putting the money must have a right. You know? If they are putting money for an investment and they are assuming a risk, they should have the right at least to be informed of the proceeding, right? Now, to take the decisions is kind of going to the edge because at the end, counsel is the one taking the decisions with the client. But I guess what Margie said is true. We should keep discussing the duty of transparency so that everybody knows that certain cases is being funded and what rights the funder has on that case. But at the end of the day, I do agree and do believe that they must have a right. They're putting the money, as simple as that.
I think there's, as an arbitrator, there's one thing I don't want to know, and it's the financial agreement in that third-party funding. I don't want to be tainted by knowing how much they're willing to put and then how much they're getting out of the award, because I think it underlies some assumptions on the probability and how strong the case is. And that is one thing I, as an arbitrator, don't want to know, and I don't think I need to know.
Well, I'm not so sure that you don't need to know. If you read, for instance, declarations yesterday made Lord Hoffman about the corruption in the Nigeria case, he said, we don't know what's happening behind the screen, but some people react saying, but you should react, you should investigate. But anyhow, let's leave the things like they are. Luis Onate is sending me messages that the time is over. I think the conclusion is very clear. the ISDS will continue to exist in 20 years' time, but we have to modify lots of things, and we agree that probably those modifications depends very much on the experience we have during those years so active in investment arbitration. Thank you to the panel. Thank you to everybody.